Now we will move to the part 2 of our opening ceremony, Bob Heppel Award for Distinguished Achievements in Labor Law, named by a scientist and lawyer whose life proved that we are indeed boundaryless and limitless in what we can achieve. Short introduction will be made by my dear colleague, Piotr Grzebek, our superhero of all financial matters of the conference. Hello, Warsaw. Hello, Warszawa.
Thank you, Isa. So welcome one and all to the second part of the opening ceremony, which is a Bob Heppel Award. So basically, we will proceed as follows. Professor Anthony Forsyth, who is already on the screen, as a chair of the nomination committee, will shortly present the works of the committee, and his short speech will be followed by the presentation of two award recipients, which is Professor Monika Schlachter and Matt Thinking. So, Professor Anthony, the floor is yours.
Thank you. Great. Thank you very much, Piotr. It's customary in Australia to begin by acknowledging the traditional owners of the land from which we are speaking. So here in Melbourne, I respectfully acknowledge the people of the Eastern Kulin Nations, their ancestors, elders past and present. It's a very great honour to have been asked to chair the nominations committee for this year's Bob Heppel Award, awarded to two preeminent international labour law scholars at each LLRN conference. And I thank the other members of the committee that decided upon the awards, the nominations committee. So Professor Tonya Novitz, Stefan Van Eck, Anna Virginia Gomez, and Piotr Grzebek. We worked together very well virtually early this year to work through and decide upon the two winners from the 11 nominations, and I thank also those who nominated the various nominees for this year's award. And it certainly was, as is often the case, an illustrious field of nominations. And I offer my warmest congratulations on behalf of the LLRN community to the two recipients of the Bob Heppel Award for Distinguished Contributions to Labour Law for 2021. They are Professor Dr. Monika Schlachter of the University of Trier in Germany. In addition to her substantial body of published work, Professor Schlachter has had a substantial impact on labour law, not only in academia, but also as a judge and through the provision of expert knowledge to public policy development at European community level. And secondly, to Professor Matthew Finken of the University of Illinois in the USA. Professor Finken's voluminous publications over many years would rank him among the leading academic contributors to United States as well as to international and comparative labour law. And his stewardship of the Comparative Labour Law and Policy Journal, to which so many academics in the LLRN global community have contributed over the years, is also highly meritorious. So now I would like to call on, firstly, Dr. Miriam Kuhlmann-Klock to present the award and say some further comments in support of the presentation of the award to Professor Dr. Monika Schlachter.
Thank you. So let's start with the laudatio. It really is a great honor for me to introduce Professor Monika Schlachter as one of the recipients of this year's Bob Heppel Award for his distinguished achievements in labour law. And this is even more special for it marks the 10th anniversary of the Labour Law Research Network, a network which Monika has been an active member of since its establishment in 2011. It is an enormous pleasure for me to introduce to a sharp and open-minded labour law scholar and a very pleasant, helpful, and humorous travel companion, and as a role model. But let me first start with Monika's scholarly achievements. When you look at her track record, it becomes immediately clear that she has immensely contributed to the discipline and further development of labour law. not only at the national level in Germany, but very importantly also at the international and the European level since she started her academic career in the 1980s. Her academic adventures started at the University of Göttingen. And not only did Monika study law in Göttingen, but she also received her doctorate as well as her habilitation. For those of you who are not familiar with the German legal system, a habilitation is a postdoctoral teaching qualification which is required in higher education in addition to a doctoral thesis. Monika's interest in studying labor law beyond the German borders and to explore the impact of international and European labor law on national law, as well as comparative labor law, certainly has been inspired while she was a research assistant of Professor Franz Gammelschek in Göttingen. Since then, she has become a leading expert in the field of labor law. Knowing Monika for more than 10 years now, when I was working on my PhD thesis, I can say for sure that she has inspired her colleagues in Jena, Regensburg, and now also in Trier to look beyond one's own jurisdiction. Monika's extensive body of work covers many fundamental areas within labor law, a large number of them addressing the increasing influence of EU law on national law, as well as the relevance of international labor rights within the European Union and the national legal systems. Quite early on, she studied various crucial elements in collective labor law. For instance, in her doctoral thesis, she focused on methods of interpretation in labor law, particularly focusing on the Works Council's rights of co-defamation, and connecting the collective elements of labor law with non-discrimination law. She has published on the prohibition of age discrimination and analyzed the extent to which social partners play a role in this. And one of her recent edited collections, published in 2019, scrutinizes the right to strike in essential services from a comparative law in action perspective. Comparative labor law always has been at the heart of Monika's scholarship, of which her monograph, Ways to Equality and Comparative Legal Study of Labor Law in the Federal Republic and the United States, is only one example. Embracing the need to look beyond one's own jurisdiction is closely linked to studying the mobility of workers, either via the free movement of workers or the posting of workers, and in particular also the role of private international law in governing the law of the employment contract. It is this area of expertise that has resulted in her engagement in the multi-annual Formula project. The Formula project, for those of you who are not familiar with it, was a project on the free movement, labor market regulation, and multilateral governance in the enlarged EU-EEA area, taking a Nordic and comparative perspective on issues that were raised in the context of the EU enlargements and the mobility of workers. Her 3 thematic papers in this project address the role of the Services Directive, the Posting of Workers Directive, and the linkages of the former two with the Temporary Agency Workers Directive. Monika's publications and engagement mentioned so far provide only a glimpse of academic achievements through which she contributed to the development and further understanding of labor law as a field. It is fair to say that Monika's interest in exploring labor law beyond the national legal boundaries, and perhaps even more importantly, her choice in persistently pursuing that interest, a choice which I can imagine has not been an easy one, considering the fact that she started her academic career in the 1980s, offers some insight in Monika as a person, namely that you can come quite far if you try to remain authentic. Yet her choice to follow her passion has resulted in she being awarded with the prestigious Bob Happel Award today. But besides being passionate academic, as we have already heard, who shares her enthusiasm about international and European as well as comparative labor law with other scholars across Europe, Monika also immensely contributed to promote the importance of international social rights, not least due to the fact that she has been a member and also the vice president of the European Committee of Social Rights, the guardian of the European Social Charter, meeting 7 times a year and usually in Strasbourg. It is worth mentioning that Monika was the rapporteur of one of the most well-known decisions of the committee, namely the decision on the Irish Congress of Trade Unions versus Ireland, which was submitted to the committee in 2016. This case concerned the question whether excluding self-employed workers from concluding collective agreements, setting out minimum rates of pay and other working conditions, which would amount to a breach of competition law, as we all have known for the past years, does violate Article 6 of the European Social Charter. However, limiting this laudatio only to Monica's academic achievements would not do justice to the person she is. Therefore, I think it's time to say something about the peculiar place where Monica is working, which may have had an impact on her scholarship as well. Not only is Monica an exceptional person, one of the warmest, most authentic and generous people I have met over the past 10 years within the Labour Law Academy, giving helpful advice whenever being asked to do so, and being supportive of young and in particular also female scholars. And if I remember correctly, Monica once told me that she is also a mentor for female scholars at her current university in Trier, assisting younger scholars to pursue their own path, either within academia, but also outside of academia. Moreover, when visiting Monica at her Institute for Labour Law and Industrial Relations in the European Union in Trier, you can observe her being part of a motivated group of scholars, and she's interested in her professional and private well-being. The daily lunch I was welcome to join when at the Institute in the canteen is part of her way to see her colleagues and visiting scholars and to engage with them. Before coming to an end, I should say something about the place where she works. Some of you may have visited her at the Institute of which she's the director, and you perhaps may share my impressions I'm going to share. Those of you who have not visited Trier yet, I can only wholeheartedly recommend you to do so. Overall, it is safe to say that the Institute is quite remote, and that is due to the fact that it takes quite some travel time to get at the Institute. However, once you arrive, you will find the Institute uphill, where you will have a tremendous view over the city of Trier, which is of historical importance itself. The Institute is located in the beautiful Moselle region and surrounded by one of Germany's most beautiful vineyards. Yet the place with its enormous library, which is excellent, and its location does remind me a little bit of Thomas Mann's Zauberberg or the Magic Mountain. And please don't get me wrong to think that the Institute resembles some kind of sanatorium. It really doesn't. But it's more the kind of view to get there. Having a research institute uphill with so many windows available into all 4 directions that allow you to take a gaze at the surroundings facilitates an all-round view and vision, features that are clearly reflected in Monica's work and life. To conclude, it is my great pleasure to present you the Bob Happel Lifetime Achievements Award to you as a gesture of appreciation for your contribution to the discipline of labor law. And therefore, I would like to invite you to raise your glass and toast to you, Monica, as being a great scholar. And I hope to meet you in person very soon this fall in Rome, if I remember correctly. Thank you so much.
Thank you very much, Dr. Koolman-Klok, for that wonderful insight into the very rich career and contribution of Professor Dr. Monika Schlachter. And certainly you've inspired me to hopefully visit Trier one day if Australia's borders ever reopen. That would be a lovely thing to do. And I would now like to call upon Professor Dr. Schlachter to respond in accepting the award that we have presented to her.
Dear Miriam, thank you for your very kind words. And actually, I would be very proud to welcome any visitor to the Institute, as we always do. It is remote, but anyhow, it is worthwhile. Dear committee members, dear President, dear colleagues, it is a huge honor receiving the Labor Law Research Network's award, and any recipient cannot but repeat this sentence. One might feel a bit surprise on the one hand and a lot of gratitude on the other. However, there are only so many potential expressions of thank you as an answer. So allow me to speak of my first encounter with the work of Bob Heppel instead, the distinguished namesake of our Networks Award. This might provide an additional explanation for why receiving it close to the end of my professional career feels almost like closing a circle. When I started my research as a newcomer, entering the team at Göttingen Institute, little did I know about comparative labor law, only that this was the chosen specialization of my new boss, so that I better started getting into it as soon as possible. After a while, the boss assigned me to a new task. I should do the book reviews for the Institute. He assumed I would learn more by not only reading books, but also understanding their fundamental approach through reporting it back to others. Between the many books sent to my desk was the one that the boss paid specific attention to, Bob Heppel's The Making of Labor Law in Europe. Some of us might have approached the reissued version of this book in 2010, but the original has actually been published already in 1986. It became immediately clear that I should better get this one right, as it was considered of major importance. A prominent reviewer from the UK, Lord Wedderburn, announced it as a major contribution to comparative legal scholarship. For a newcomer to the field, however, there is no way of presenting a review as a judgment. You have to find another way of approaching the topic. So what was it that made some contributions more lasting than others? And how are comparative studies so special? Bob Heppel's book explains how labor law took shape in the then member states of the European Economic Community, as the Union was called at the time. And he led to bring it back to the consequences of the member states' respective approaches to the everlasting social question. We learn from authors from different countries that legal developments may differ fundamentally, even if they start from a common problem. The decision for a specific solution was clearly dependent on the social and economic differences between states. Different theoretical and systematic approaches may have a role to play too, but a different practice is dominant for the legal solutions developed. The struggle between social classes or economic powers influences the emergence of labor law, best suited for the main players' purposes. Such insight remains relevant today, also under the current crisis conditions. Additionally, comparative studies offer practical gains too. Initially, we learn more about foreign legal systems, but that is only the beginning. We then learn different things about our own legal system, things one might otherwise have never considered at all. After going through a lengthy training in law, fundamental approaches of one's own legal system tend to become self-evident, almost as if they were laws of nature. In legal systems taking pride in their delicately woven fabric of dogmatic, the insight that many results could quite as well be different from what we consider the natural outcome is almost heresy. Getting away from what took so much effort to learn, opening up for potential alternatives, might represent an advantage of comparative law. It is also most relevant for practical research, specifically for international projects. We need this openness for creating cooperation, and structure a relevant research agenda. Finally, when practicing international law, the comparative approach alleviates compromise solutions by acknowledging many equally legitimate solutions to one legal problem. All taken together, comparative labor law was and still is a fascinating subject. For me, personally, the making of labor law in Europe represented a starting point, the basis for my interest in the field. Thanks to the decision of the nomination committee, I now return to Bob Heppel in gratitude to where I started from back in 1986. Thank you.
Thank you very much for your wonderful comments and humble acceptance of the award, and also for making those connections back to the person, of course, after whom the award is named, Bob Heppel. And again, Professor Schlachter, please accept my congratulations on behalf of the whole LLRN community. I'd now like to invite my friend Professor Takashi Araki to make some comments in support of the award to the other recipient this year, Professor Matthew Finken.
Can you hear me?
Yes.
Okay, great. Right. Oh, it's my great honor to introduce Professor Matthew Finken as a recipient of the Bob Heppel Award. Matt is my mentor of American labor law, a colleague in comparative labor law studies, and a close friend. Matt Finken was born in April 1943, and after graduating from NYU Law School and Yale School, he taught at Southern Methodist University School of Law from 1970 to 1988. And since 1988, he has been teaching at the University of Illinois College of Law. Matt Finken's outstanding achievements in U.S. labor law would be sufficient to mention just a few of his well-known books, such as Labor Law Cases and Materials, Legal Protection for the Individual Employee, and Labor Law Analysis and Advocacy. Especially, Labor Law, Privacy in Employment Law, first published in 1995, and fifth edition published in 2018, is considered as the Bible on privacy issues in employment relationship. I myself have learned a great deal about American law from Matt Finken's writings. However, the occasion of presenting the Bob Heppel Award, I would like to focus on Finken's contributions to comparative labor law studies. Matt Finken spent 3 years, from 4 to 7 years old, of his childhood in Japan, starting in 1947. Because of his father's military service in Japan. Therefore, his first foreign language was Japanese. I don't know whether his exposure to a language with a completely different system like this from an early age stimulated linguistic ability, but Matthew has developed a great talent for languages, which has advanced his study of comparative labor law in particular. Based on his understanding of German French law, he has published numerous articles in the German and French languages. He has given countless presentations at international conferences and seminars, and invited lectures around the world. Matt Finken's talks using American labor law from a comparative perspective has enabled audiences to understand the unique position of American law and stimulated fruitful comparative discussions. He has not only discussed American law, American labor, employment law, has also written insightful articles on comparative labor law itself. These include Introduction, the Past and Future of Labor Law in Comparative Perspective, which appeared in International Encyclopedia of Comparative Law in 2014, and Comparative Labor Law, published in the Oxford Handbook of Comparative Law in 2019. Matt Finken's contributions to comparative labor law have not been limited to his own writings. Notably, he has succeeded the editorship of Comparative Labor Law Journal from Clyde Summers, Janice Spirach, and renamed the journal as Comparative Labor Law and Policy Journal, inviting Sanford Jacoby as a co-editor, and has developed the journal into a central arena for comparative labor law and policy studies. We are well aware of how many of the world's leading scholars have contributed valuable papers to the symposia of this journal. In addition, as an editor, Finken published comparative labor law books such as Part-Time National Human Rights Management and the Law in 2013, and Comparative Labor Law in 2015, collaborating with labor law scholars in various countries. These are invaluable assets for comparative labor studies. Currently, Matt Finken's work have been translated into 7 languages and are read all over the world. For these international achievements, he has received honorary doctorate from universities in Italy, Germany, and Greece, and a special honorary award from the French government. Finally, I'd like to share a personal story. In 1998, Matt sent me an email because he was interested in an article I had written on employment security in Japan. Then he and I began an academic, personal, and family relationship for the next 20 years. I will never forget the warm hospitality that Matt and his wife Eleanor extended to our family when we stayed in Champaign, Illinois, 2001. His writings are always full of warmth and thoughtfulness toward others, especially weak parties. When Matt Finken organizes a symposium of the journal, he has always endeavored to invite labor law in Asia and South America, as well as those in North America and Europe. In this sense, also, his effort in the development and encouragement of comparative labor law studies are worthy of special mention. Therefore, it's my utmost pleasure to present Bob Heppel Award for Lifetime Achievement in Labor Law to Professor Matthew Finken. Thank you very much.
Thank you, Professor Araki, for your very generous comments and for summing up so ably why our nomination committee felt that Professor Finken should also receive this year's award. And I would now like to invite Professor Finken to make some comments in receipt of the award. Thank you very much. It's been great that you've been able to join us. I hope you got to hear the lovely comments from Professor Araki describing his interaction with you and your contribution over your career. So over to you to make your comments accepting the Bob Heppel Award.
Well, let me express my appreciation to everyone. You don't know how technologically challenged I am. It's amazing to me that you actually can hear me. You just nod. Yes. Oh, terrific. I have no prepared remarks. Let me just say that I was astonished by this award. I do have 5 brief points to make. First of all, to my old friend Takashi Araki, I was raised in Japan. Japanese was my second language, and I respect and indeed love the country of my childhood. One of the things I know about Japanese culture, of course, is that one never speaks very directly. There is a Japanese word for no. It is never used. I didn't know it until I was a teenager. So to hear an honest man exaggerate, particularly a Japanese scholar of Professor Araki's stature, is really quite off-putting. I'm just sort of humbled by it. But thanks to him very much for those words. Thanks also to the committee, which the award surprised me in part because I don't think I merit it. There is no Finken's theorem. There is no Finken's lemma. And as Tonya knows, I pressed very, very hard for the award to be given to someone else. So I have the firm and definite conviction that a mistake was made, but I'm happy to accept it. Even so, particularly because it isn't, and not only from this organization, and I'll have a word more to say about that, but that it's in honor of Bob Heppel, whom I knew well, who came to Illinois and was a member of the editorial board of our journal, and in addition to being a world-class scholar, was just a wonderful, wonderful human being. I'm happy and indeed humbled to accept this award. Less for me, as I said, but for the journal that I have edited now for almost 25 years with Sanford Jacoby at UCLA. We inherited this journal from Ben Aaron and Clyde Summers. And when Clyde gave it to me, he said, "This is a missionary task that you have, because America is almost impervious to the influence of comparative study in its labor law and policy." We've edited this journal for almost 25 years, and on that missionary task, and I can look back and say that we've had no impact whatsoever on the development of law in the United States, which hasn't stopped us at all. But we have been provided a venue for scholars around the world, and I'm always looking out for younger people, for the next generation. So I was very pleased that at the creation of LLRN a decade ago by Guy Davidoff and that wonderful group, astonished that it has not only grown but has drawn strength to strength. There are over 500 participants in this rather awkward forum, and I'm delighted to have the journal become a venue for their work and for scholarly interchange for all the reasons that Monica Schachter gave. I couldn't try to equal her emphasis on the role of comparative study in the global context as we all go forward, as we all face the same problems which the pandemic has brought home in a way that no other, perhaps, event could have done. So again, it is with considerable surprise and humility, but gratitude, that I'm happy to accept this award, more for the editorial board, my co-editor, and the editorial board of the Comparative Labor Law and Policy Journal, which included Bob Heppel and Mark Friedland and Manfred Weiss and Monica herself. And I'm very delighted that the Universities of Warsaw and Lodz have put this program together in the way they have. And I look forward to the next decade, maybe, of working with all of you and in the mission of study and serious engagement with the labor, with the role of waged work in advanced industrializing and post-industrial economies. So again, merci beaucoup, vielen Dank und domo arigato.
Well, thank you very much, Professor Finken, for those comments, and I can assure you no mistake was made by the nominations committee that sat in judgment of the 11 nominees. It was clear to us that both you and Professor Schlachter were the thoroughly deserving 2 award recipients this time around. Again, I thank LLRN for giving me the opportunity to be involved in this process. It's been very interesting, and it's very pleasing to see the 2 award winners that have just been presented with those awards. And thanks again to Dr. Kulman-Klock and Professor Araki for your lovely comments about both of our award recipients. I would just also take this opportunity to say thank you to the conference organisers. Things are going very well so far, and I think the platform you've chosen from this end, it's a dream to work with. So I hope it continues, and congratulations on organising this conference. And I look forward to the next few days. And I think we're a little ahead of schedule, but I'll now pass back over to the conference organisers to take things from here. Thank you.